Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are going to be talking about one specific case that's very interesting. It's a construction accident case out of New York City, and we're going to talk about how a large pain and suffering award by a jury could get changed on appeal, and whether verdicts are sustainable, meaning whether the verdict that you get from a jury is the actual money you're going to receive if you are an injury victim, and what are the factors that may allow a judge or an appeals court to take away your verdict, to take away the money that a jury has allowed for after a trial. So let's get into it. This is a case where a 29-year-old man was injured in a construction-related accident back in March of 2012. So about 12 years ago. This case has been going on for a long time. And what happened was this gentleman fell from the fourth step of a ladder while he was painting inside an apartment building in Midtown Manhattan in the East 47th Street area. So this man sued the property owner and the building manager under the labor law, and the court agreed and granted him summary judgment as a matter of law. That means that there are no issues of material fact for a jury to decide as to the issue of fault, because he was a painter, which is a covered construction activity. He was not given proper safety devices such as a scaffold or a ladder, and he fell from the fourth step and he was injured. Actually, he was given a ladder, but I guess the ladder wasn't safe, wasn't proper. I don't know the exact details, but he was granted summary judgment. And he's only 29 years old, so he suffered some serious injuries. And so they had this damages only trial, and it actually happened in the Bronx, which is a very favorable venue for plaintiffs. And the Bronx jury allowed for $3 million. Now, this is pain and suffering damages were $3 million. $1 million was for the past, meaning from the date of incident up until the trial. Like we said, the date of incident was March 12th of 2012. The trial was held in May of 2022, so 10 years later, and the jury allowed for $1 million for those 10 years. And so for the future, which is 37 more years of life, the jury allowed for $2 million. So the total was $3 million. Now the defendants, what they were arguing was that these amounts were excessive, and the reason they were excessive was because the jury improperly concluded that the plaintiff's injuries were included this claim that he suffered from CRPS, which is the complex regional pain syndrome, also known before as reflex sympathetic dystrophy, or RSD. And so they claimed that this whole thing was improper, and the trial judge reduced the pain and suffering award to $700,000, $250,000 for the past and $450,000 for the future. And the reduction was $700,000. So the judge basically took away, right? He went from $3 million, which is what the jury gave him, all the way down to $700,000, right? So that's taking away, a lot of money. That's taking away $2.3 million. And the appellate division affirmed the judge's reduction. And there was a decision from the first department. And the reason they affirmed it was because the plaintiff just didn't really have evidence of CRPS. What he had was, he had a wrist fracture, he had shoulder impingement, and he also alleged complex regional pain syndrome. However, such a finding, the appellate court wrote, was against the weight of the medical evidence, and that is because 4 out of the plaintiff's doctors, now the plaintiff called 5 doctors, right? So 4 out of the plaintiff's own 5 doctors agreed that he didn't have CRPS, right? And then 4 out of the 4 defense doctors all said he didn't have CRPS. So there was only one doctor who claimed that plaintiff had CRPS, and this doctor, his evaluations were inconsistent with his own opinion. So I guess the testing and the clinical evidence and because when you do a medical evaluation, you have to take a history, you have to do a physical exam, you do your clinical findings, and all of this was inconsistent with his actual opinion. So, and that doctor is a physiatrist, so he's not really even qualified to diagnose CRPS. And he's a doctor, by the way, I'm not going to say who it is, but he's a doctor that testifies a lot. He's known as a, maybe not the, even for plaintiffs, because you have a lot of defense doctors that are not straight shooters. But for plaintiffs, hopefully you're going to use a treating doctor, somebody who's treating you and is just a real independent, true doctor, not a hired gun. But sometimes, plaintiffs get greedy and they use people that have been around the block a few times. And I think I've seen this doctor's name a lot, which doesn't mean he's not a good doctor, but the court didn't really buy his opinion, especially since the opinion was inconsistent with his own evaluation. And so there was another doctor also, but he belatedly inserted a CRPS diagnosis in an undated addendum after a conversation with an unidentified person. So that's kind of, fishy. And so that was the only evidence they had. And so for that reason, it was slashed down to $700,000. Now the injury details, there was a wrist injury. There was a distal and ulnar comminuted fracture. Comminuted means it was broken into pieces. It was a fracture to the non-dominant wrist, treated with a cast and physical therapy for 6 months, but it resulted in a malunion because it was a comminuted fracture. It didn't heal properly, and there was a malunion, which is a serious injury. And now the shoulder, there was an acromioclavicular joint, the AC joint separation with rotator cuff syndrome and a biceps tendinitis, treated with physical therapy and a cortisone injection. So there was no surgery, and those were the two injuries. And there was extensive medical testimony at trial related to plaintiff's CRPS claim. And like we talked about, 4 of the plaintiff's 5 doctors agreed, and then 4 of the defense doctors agreed there was no CRPS. So the jury awarded plaintiff future medical expenses in the amount of $2,500,000 for 37 years. So they actually awarded him $3 million for pain and suffering and $2.5 million for medical expenses. So the total award was $5.5 million. So, this was pretty good. This was the Bronx, it's a good venue, but I guess I got to give, I don't know who the plaintiff's trial attorney was, but I got to give him or her kudos, good job, because this is a big verdict for these kind of injuries. No surgery. You have a wrist fracture and a shoulder separation, not even an arthroscopic procedure, and $5.5 million. That's pretty good. But, unfortunately, the appellate court slashed that down, and they said that the future medical expenses are based on the jury's implicit finding that the plaintiff had CRPS, which the courts now rejected. So they lowered the future medical expenses from $2.5 million down to $10,000. So pretty much almost like nothing. And so it's an interesting case. And the plaintiff, by the way, had no medical treatment for his injuries for 6 years before the trial. So if he was really, so injured, how come he didn't have any medical treatment for 6 years? That's not good. So if you're on the trial calendar, if you have a case, even if your lawyer is not sending you for treatment, if you have any kind of symptoms, if you have any kind of pain, it's good to have treatment. You don't want to have a gap of 6 years, because the defense lawyer is going to absolutely have a field day with that, and he's just going to parade that up and down the courtroom and say, look, he's so hurt, she's asking for millions of dollars. They haven't been anywhere for 6 years, and that's going to kill your case. So I always recommend people to just go at least once or twice a year. If you go twice a year, that's once every 6 months. If you go, 3 times a year, once every 4 times a year, once every 3 months, whatever, but go and go to a specialist. Go to the doctor that's the surgeon, that's the orthopedic, that's the neurologist, that's the top specialist, because that's the doctor that's going to testify. Now, you could also go to physical therapy, but that's weaker. You want to go to the specialist, just like once or twice a year at least. So, let's see what else they had. Oh, the jury also, wait a minute. The jury also awarded plaintiff lost earnings in the sum of $1 million for 21 years. However, plaintiff conceded that the award should be reduced to $302,000 because that's the amount calculated by the plaintiff's expert. So this was like a little bit of a runaway jury. It was interesting because, you know, if the plaintiff's own expert is saying the lost wages, the lost salary is $300,000, $302,000, why is the jury giving him $1 million? I don't know. But the plaintiff considered that was reduced. So actually, it was nearly $6 million. So this is a really good verdict. It was 5.5 plus this 300,000, so 5.8 million altogether. So that's the case. Let us know what you think. I think it's an interesting case. And the appellate court, if we look at the appellate division decision, they basically said that the court has discretion to set aside an award for future pain and suffering or past pain and suffering if the amount is just not supported by the credible evidence, and there was no, and it was based on unreliable and speculative evidence, and there was no, the jury award has to be supported with evidence based upon reasonable certainty in the record, you know, to a reasonable medical certainty, and it didn't really have that because you just had this one doctor who was, you know, contradicted himself, and this other doctor just kind of inserted the diagnosis in there because he spoke to someone, maybe somebody from plaintiff's attorney, without any like foundation. So you can't do that. So if you're building a case, you got to build it the right way. You have to get the real experts, the real CRPS doctors. You know, don't get somebody who's not a CRPS clinician and just stick in CRPS. That's not going to work. You see what happens. So, and it's unfortunate because they've been fighting this fight since 2012, you know. I mean, 12 years, and only to have it slashed to such a tremendous amount. Like, you know, you get 2.5 million in future medical expenses, you get slashed to 10,000. You get $3 million for pain and suffering, it gets slashed down to 700,000. I mean, 700,000 is still something. It's a good settlement, but you know, it's a big slash, $2.3 million slash, just taken away because of that. So. You know, and the other thing is, look, if you don't really have CRPS, then why base the case on CRPS? Maybe just mention CRPS if the jury could allow for a little bit more because of that, but I would base the case on whatever he did have, whatever was the reason that, you know, he can't live his life, or he can't work, or he's having pain, you know, whatever is the most debilitating medical evidence and the real impact to his life. So in that sense, you know, that maybe was a mistake by the plaintiff's attorney, but it's hard to say without reading the entire trial transcript and going back over everything. But I hope this was helpful. Let us know what questions you have. And it's interesting because, you know, you have to have medical evidence, and, you know, even though you're in a good venue where the jury is going to give you a lot of money, doesn't necessarily mean you're going to get to keep that money. So, okay, let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. And if you have any questions, feel free to comment or text me directly, and I'm happy to schedule a consultation or chat with you. My number is 347-566-9595. Okay, have a great day, everyone. Bye-bye.